The impact of a Miranda rights violation in your Oklahoma case. I'm Tulsa attorney James Wirth. That's the question that we have. So first off, Miranda rights violations, that's going to be applicable to criminal cases. If the state is trying to prosecute you, or the city is trying to prosecute you, or the feds are trying to prosecute you, then they could be a potential Miranda rights violation. We've all seen that on various cop shows and TVs where they're getting ready to interrogate you, and they have you read your Miranda rights. In practice, they actually have you to sign a sheet off where you're acknowledging those rights. Then they ask you the questions so that the statements that you make are admissible and they can use them against you. They told you ahead of time they're going to use them against you, and they do it anyway. So first thing, obviously, if you're in those circumstances, you don't want to talk. You have the right to remain silent, and you want to use it. You want to remain silent, whether they give you Miranda rights notice or not, and whether you sign off on that document or they just tell you and they read it off that card, you're going to want to remain silent regardless. However, what if you do talk and they didn't provide you that Miranda notice? What exactly do you do from there? What do you do about that violation? And typically what we see, and the more practical outcome of that, is that you request to have all of the information obtained from that interrogation excluded as evidence. Use the exclusionary rule. Say the cops broke the rules, they violated Miranda, therefore they can't use the ill-gotten gains from that. So you could technically, allege, violations of the law, maybe file a civil lawsuit. That's not what happens in practice. It's not worthwhile to do that. What in practice you do is you try to suppress those statements. So the only benefit you get is that the statements that they got after a violation of Miranda, they can't use against you, which is the same result you would have had if you had not said anything in the first place. However, sometimes they can use those Miranda violation and get that statement from you, and then use that statement to get additional evidence, and then try to use that evidence against you. And it's not guaranteed the court's going to suppress it all, though that'll be the request the defendant would make. So you're way better off not speaking whatsoever, using that right to remain silent. But if they do not give you a Miranda warning and it was triggered, which it's triggered by you being essentially, detained, and them asking questions that would have a reasonable belief could lead to incriminating information. If those circumstances are present, Miranda is triggered. They need to give you that Miranda warning. If they don't, you can request that they suppress those statements that you made, but the better bet is just not make those statements in the first place. All right, if you're dealing with this, a criminal prosecution case, talking about defenses and what evidence can come in and what can't, and how the police violated your rights, you're going to talk to an attorney privately and confidentially to get legal advice specific to your circumstances. To schedule that with an attorney at my office, you can go online to makelawEasy.com.